Good day. My name's Sam Kemble with Workforce Delivery Inc. Today, I speak to you about a case that was recently released out of Newfoundland and Labrador. And the reason it's of interest to many in my network, at least, is it pertains to an employer's duty to accommodate a worker working in a safety-sensitive position while on medically prescribed marijuana. And the arbitrator had to get into that discussion. In addition, the arbitrator had to consider also the employee's obligation to disclose that a medical prescription which may impact that employee's ability to work safely. So this actually occurs on the lower Churchill transmission line. The parties to the dispute are the International Electrical Union Local 1620 and Ballard Construction, represented by the Lower Churchill Transmission Line Employers Association. I think this stuff is interesting. I think that this case will be useful, but I'm a labor relations geek. And but if you find this interesting, please click on the logo on the bottom corner of our screen here, and you can subscribe to my videos for future updates. We do videos from time to time on the administration of safety work rules and also human rights related work rule administration. And also we discuss the labor market in general in terms of procuring the right industrial workforce for projects in Western Canada. So again, if you're interested in this, please click the logo and subscribe to our YouTube channel to see future updates. But in the meantime, we're going to get into this, and as usual, the devil's in the details. And why I wanted to jump in front of this and do this video is to walk through some of the details on the fact set of this case, just so that employers don't move forward too aggressively or without due care and concern, because there are certain facts inherent in this case which I think lent also to the outcome that arose from it that might not be replicated in every situation. So safety managers, human resource people, labor relations people, project managers, superintendents, we need to be just as diligent as we ever have in administering these work rules. But I will say this arbitrator did show signs that the legal community are starting to understand what employers have to go through to keep the workplace safe, especially within the context of alcohol and drugs at the workplace, whether they be illicit or medically prescribed. So I just want to hit right off the hop here the poor unfortunate soul aspect to this case. And on first blush, you hear of an individual which is, going through obviously some kind of medical concern, is prescribed marijuana as medication, and then loses their job. And sympathy should certainly be a factor. Employers need to treat their employees with care and concern within the context of what employees are going through. And that's my case. That's how I treat these files, and I'm going to stick to it. And I think that's the best way to go. I also, as per usual in a lot of these cases, the employee's hands aren't completely clean in this matter. And I can tell you, I don't think I would ever imagine that I'd be standing in front of a PowerPoint presentation broadcasting to my network in front of the Fast Times at Ridgemont High bus behind me. But it is apropos because that's how this issue came to light. The individual in question didn't voluntarily disclose that he had a medical condition. He also didn't disclose to supervisor, in accordance with the alcohol and drug work rule, that he was taking a medication that could impact his ability to work safely. He stashed his marijuana, a large portion of his marijuana, outside the camp gate in a ditch by the road. So he knew that the camp and project didn't allow marijuana on site. He did take some marijuana with him and had it with him while in camp, and ultimately was found because the security guard confronted both himself and 3 of his co-workers while in a pickup truck, because the security guard noticed the whiff of marijuana emanating from the truck. So again, yes, the medical concern that this employee and others have to face is concerning, and we have to treat all this stuff with compassion. I just wanted to put that out there so you know that this employee was obviously, knowing that he was doing something wrong, was quite deceptive in the way that he was going about it. It seems to suggest that there was use on the site. Also, if the smell was coming out of a truck with 3 of his co-workers, he might have been impugning 3 of his other co-workers, causing a larger safety risk than just himself by having access to the marijuana. But in any event, one of his defenses to this, and the union's defense, is after all that, he was honest once confronted by the security guard. But we'll get into that. So just to highlight the facts, what brought this in terms of an arbitration decision was the griever was ultimately terminated for violating the alcohol and drug work rule, and namely for refusing to disclose or failing to disclose that he was on a medication that it could impact his ability to work safely. And also, he was terminated for having possession of an illicit or prohibited substance while on the work site. Just a little bit about the safety sensitivity of the site. It was not argued or didn't appear to be a feature of conflict in this arbitration decision. I do believe that the union and the employer both seem to accept that both the project was safety sensitive and the work that the individual was doing was safety sensitive. So there wasn't a whole lot of black ink in the decision spent on establishing the safety sensitivity, but it's worth commenting. The project itself is in regards to a very, very high voltage line. So there's the project itself is safety sensitive, also has public safety and health concerns in the event that it was not built correctly by people who were of sound or absent impairment. That's on the quality control. But the actual work that the workers were doing was also safety sensitive, and the individual was operating equipment which also in itself has inherent safety sensitive nature to it. So that wasn't in dispute, but it's worth noting that contextually, especially as it relates to an alcohol and drug work rule, that contextually this occurred on a safety sensitive work site and also by a worker that was performing safety sensitive duties. And in addition, another curious aspect of this, interesting aspect of this case is the worker alleged that he was taking the medication in accordance with his doctor's instructions, and that was certainly one of the defenses that the worker had put forward. And at the end of the day, that wasn't absolutely the case as well, but there's problems with that. So here he's a relationship with a general physician who's working through just the pain and the anxiety aspect that that patient and client relationship they're working through that. And the physician just puts on, do not operate heavy equipment for 4 hours after using the medication, and use it in accordance with Health Canada guidelines. Now, Health Canada guidelines also had changed over the course of this individual receiving the prescription, and the guidelines are suggesting that after the medical marijuana use, that individuals shouldn't operate or drive 24 hours after using the medication. So the individual wasn't, well, he may have believed that he was complying with doctor's instructions, but he actually wasn't because of the change in the Health Canada guidelines. But even absent that, and the decision does get into this, even if the individual was actually in a very pristine way taking the medication in accordance with the doctor's instructions, that is not enough. That does not satisfy the worker's obligations and duties to report to his supervisor that he is taking medication that could impact his ability to work safely. And that was a very interesting part of this decision. And it's a nice sign because the arbitrator is starting to acknowledge that general physicians, A, don't know what kind of work the individual is doing necessarily, isn't aware necessarily of the safety sensitive nature of that kind of work, the work that the individual is doing. Also, there's an acknowledgement that general physicians may or may not have even taken any occupational health training through the course of their education, and just realize that the client-patient relationship is a completely different purpose as opposed to assessing an individual's ability to work safely on a safety-sensitive work site. So the fact that the individual was, or purporting to, have been taking the prescription in accordance with doctor's instructions does not relieve the individual's responsibility to disclose that they were taking medication that could impact their ability to work safely. And this is a good decision for that, and there's a good dialogue in there, so it might be worth keeping that on file for future reference. In addition, the other thing that was kind of interesting too is the arbitration explicitly stated, now this is timely, the arbitrator and the courts even verified, explicitly stated that this whole decision, this whole issue is neutral when it comes to the changing regulations in regards to changing federal regulations in regards to medically prescribed marijuana, and it's completely neutral on the changing regulations regarding the legalization of marijuana. So this case actually says those fairly highly visible and highly public changes to public policy around medical marijuana and marijuana in general do not have a direct bearing on the administration of employer alcohol and drug work rules, particularly in safety-sensitive work sites. So that was interesting and also worth keeping at your fingertips for future reference. I'm sure, in spite of it not having a direct influence on the administration of, or the ultimate outcomes of administering alcohol and drug work rules, labor relations, HR people, safety people, project managers, project teams are not going to be short on discussions around what does it all mean when the law changes. So it's good to have this decision and know that it exists. So it verifies that, yeah, we can just keep doing what we were doing. We're just doing it within the context of a different public policy marijuana environment. In addition, the arbitrator found that it was a bona fide occupational requirement on the part of employers, justifiable on the part of the employers, to have their workforce in safety-sensitive positions and on safety-sensitive work sites to be below the marijuana or the cannabinoid panel thresholds set by the alcohol and drug work rule, even within the context of medical marijuana. Now that is really quite important. In this particular case, further, the union failed to establish a prima facie case for discrimination. And in addition, the employer or the arbitrator found that it would have been to the point of undue hardship, and there was no requirement for the employer to accommodate this particular individual. Now there's a couple, I just want to take a step back there because there's some fact set specific factors that I think led to that, help the arbitrator get to that conclusion in this case. So I'm not interpreting this case to be a blank check for employers on duty to accommodate or making sure that they're not discriminating in these kinds of situations. But the logic flows is this worker was not forthcoming and transparent with there being a medication that he was taking that could impact his ability to work safely. The deliberate concealment and stashing his drugs in ditches and hiding it and keep bringing the marijuana onto the campsite. All that dishonesty didn't equip the employer to be able to assess the situation and see if there was possibly some accommodation that could have been afforded the individual. So the individual's lack of being forthcoming put the employer at a slight disadvantage, and in fact that into itself reduced the employer's ability to accommodate. So having said that, the arbitrator looked at that and basically reduced the obligation of the employer to accommodate individuals in this circumstance, just because by the individual's own dishonesty, the employer was unable to do so effectively. And in addition, the union actually failed to even ask for accommodation, which rendered some of this moot. So the fact that this decision did find that the threshold levels, maintaining the threshold levels even within the medical context in this case, was a bona fide occupational requirement, and that there was not a duty to accommodate on the part of the employer, I think is maybe a positive trend, but I wouldn't say that it was an established standard. And even within the text of this decision itself, the arbitrator repeatedly states that this has to be measured or administered on a case-by-case basis. Okay, so we still have to be as diligent as we ever were in respect to this, and administer each of these on a case-by-case basis. Now, if, in my opinion, if the individual was totally upfront, forthcoming, and not dishonest, not concealing, and advised the employer ahead of time, I think there's a good possibility that the results and findings of this particular arbitration may have been different. But I do think the arbitrator was impacted by the blatant dishonesty of this griever. The union relied quite heavily on verbiage in the policy, not so much the Canadian Alcohol and Drug Work Rule policy, but in the Ballard Construction's handbook, where the words zero tolerance were stitched through the employer's work rule. And the union was pointing to that language to suggest that, and there has been case law, where if alcohol and drug work rule cases aren't administered on a case-by-case basis with automatic consequences, that those cases are often reversed in favor of the employee if there's automatic consequences. So the union pointed to the phraseology around zero tolerance to imply that this was a foregone conclusion or an automatic consequence. And the arbitrator rejected that too. They seemed to distinguish between having a zero tolerance work rule or a safety absolute nature of a work rule, and understood the need for that in managing a system of safety on site. But those words itself did not impugn or preclude an employer from managing cases on a case-by-case basis when it comes to what is the remedy, consequence, or findings as it relates to an individual who may be found afoul of the work rule itself. So that is useful, where there's a zero tolerance, and in this case there was a zero harm safety philosophy. It was a safety absolute, and the alcohol and drug violation of alcohol and drug work rule was promulgated across the site is a zero tolerance work rule, which is important because workers who may lose their job shouldn't be surprised by the fact that they lose their job because of the zero tolerance nature and the safety absolute nature of the work rule. But having said that, the arbitrator did make that distinguishing feature to say, yes, that is important, but also that doesn't preclude an employer from handling these on a case-by-case basis. And then the arbitrator goes on further to say, and an employer must handle these on a case-by-case basis. So, but in any event, a zero tolerance policy itself is not discriminatory. That was the finding of this arbitrator. Now, would I say that that language is my preferred language? Maybe not. But in any event, it does show that there's some understanding around managing a system of safety and a delineation between that and addressing individual circumstances which shake out, as they often do on project sites. The arbitrator answered the questions, or had to answer questions, regarding the duty to disclose within the context of privacy obligations that employers have to their workforce. And the arbitrator found in the analysis that it was not an unreasonable request or an affront to the workers of privacy for the employer to request or know if individuals in safety sensitive positions were taking medications which could impact their ability to work safely. So the arbitrator went further into a privacy analysis and did find that that was a reasonable use, collection, and required disclosure of personal information on the part of the employer in administering his safety sensitive, the employer's safety sensitive project. In addition, this griever, the individual that was so forthcoming after being confronted by the security guards who smelt marijuana coming out of the pickup truck when he had 3 of his co-workers with him in that pickup truck, he put forward as his defense that he told his buddy on the tools that he was taking medical marijuana or had a prescription for medical marijuana. And that buddy, who he was working together with on the tools, who was ultimately promoted to a supervisor or foreman position, the individual, the griever, said that, well, then he had satisfied his obligations to disclose to the employer. And the arbitrator, fortunately, did not accept that as well. The arbitrator found that the individual had to disclose in the format that the employer required people to disclose, and telling a friend of yours who later becomes a foreman does not satisfy the obligation to report in the Canadian Alcohol and Drug Work Rule. And for all we knew, the individual that he disclosed that he had a medical marijuana prescription might have been in the truck with him smoking marijuana, but we don't know that. It is nice to see, though, that the arbitrator clearly had some street smarts in respect to this, and it was a pleasure reading his decision on that account. Another reason why this decision is important is the misconduct of the conduct of the employee is established both in the arbitration hearing and reaffirmed at the court level that indeed is misconduct. So it found that yes, the policy established a requirement for the employee to disclose the medication that the employee was on if there was a possibility that medication could impact the employee's ability to work safely in a safety-sensitive position. And from there, found that this employee deliberately concealed the fact that he had a prescription for medical marijuana, and that violated that work rule. Also, the arbitrator and the court found that there was a logical connection. The arbitrator and the court also found that marijuana in someone's system exceeding the thresholds contemplated by the Canadian model alcohol and drug work rule increased safety risk regardless of whether it came from illicit sources or it was there as a result of a medical prescription for marijuana. So regardless of how the marijuana got into the bloodstream or the individual, it didn't matter. It increased safety risk. And this is important because the language used by the arbitrator in this case, and again confirmed by the court, tilted towards safety risk versus language that we've been seeing since Entrope in Ontario around impairment, which I've long thought that courts and arbitrators focus too heavily on impairment versus safety risk, which is essentially inconsistent with today's standards of managing safety, which is looking at leading indicators and preventative measures versus after the fact controls. So yes, the arbitrator and the courts are using words associated with managing risk of safety and hazards at the workplace versus impairment, which is really nice to see. And the court went further, and also the arbitrator first, and then the court also reconfirmed it, but found that there was a logical connection between the work rules that were established by the policy and the objectives that the business was trying to achieve, and concluded with finding that the individual, in fact, the misconduct under question, in fact, violated a safety absolute, which was essentially the arbitrator adopting the language that is used in the project work rules. So it seems that the decision makers in this case bought into the management of safety risk, the importance of that, and also bought into the concept of safety absolutes. The court did have problems or questions regarding the arbitrator's findings surrounding quantum of discipline, that being the rationalization or the endorsement of the just cause termination. And at the end of the day, once the arbitrator got to the point that the individual had violated a safety absolute, and all the analysis of rationalizing that work rule, finding that work rule was rationally connected to the purpose that the employer was trying to achieve, then the arbitrator relied in the decision, in the written decision, in his articulation of his decision, too heavily on the fact that the individual had violated a safety absolute to justify the termination. And the courts wanted the arbitrator to go more deeper into that analysis. In terms, they wanted the arbitrator to show his work. Now, safety managers know that safety absolutes are written, they're rules written in blood, as often you hear on different sites. Arbitrators, I think, get that as well. And it kind of gets back to the similar kind of discussion on the zero tolerance versus assessing individuals on a case-by-case basis. Once you violate a safety absolute, we still need to show our work as to why a just cause decision is appropriate under the circumstances, and the courts just didn't see that in the decision. The court didn't disagree that could be the right decision. They just didn't see the logic. They wanted to see the work behind it, and so the court had an issue with that. Also, they wanted an explicit analysis regarding the proportionality of termination relative to the offense itself. And they wanted an assessment. They wanted the arbitrator to explain more deeply how the arbitrator concluded that accommodation on the part of the employer or afforded to the employee by the employer would not have been appropriate under the circumstances. And in addition, there was just a few things, and again, this would have been handled if the arbitrator had been explicit in his rationalization as to supporting the just cause termination, but the griever, the union had put forward that the griever had a clean record. It was 4 weeks. We'll get into that in a moment. But the union put forward that the griever had a clean record, and that and this was quite distracting. The employer actually put the individual back to work. So once the employer found out that the individual had a prescription for medical marijuana and was taking that prescription, the site management for Ballard Construction put the guy back on site and he worked for 5 days before someone probably more senior in the organization intervened and said, "You've got to get this person off the tools." But rightfully so, it sent a fairly distracting message to say, well, do you have a concern with this person's ability to work safely or not? And it was just a horrible decision to send that person back to site, and I'm sure some site manager on the lower Churchill transmission line had let's call it a learning moment with some more senior management within Ballard. But regardless, that was just it's an irritant on my perspective, because that's just a bad management practice. It's a bad management call. But in any event, it was distracting, and the court sent it back to the arbitrator. And if at first you don't succeed, try again. And arbitrators aren't always given that luxury. But I do know that employers are never given that luxury. But it's actually the employer on trial, not the arbitrator. So basically the court just said, look, we just need you to explain yourself further, and sent this specifically the question as to how the arbitrator arrived at supporting a for-cause termination back to an arbitration hearing. Management's case for just cause included a review of the length of service of the griever, and which was 4 months at the time, and actually countered the concept that the griever had a clean record, because the evidence actually showed or demonstrated that the griever was deceptive and was in fact violating the work rule from the moment that he stepped on the project. So he just hadn't been caught for 4 months. So I thought that was an interesting argument, and it carried weight with me, in fact. Also, management countered the potential that this could be construed as a isolated incident or an impulsive incident, describing and highlighting for the arbitrator that it took a lot of planning and deliberation to conceal what he was doing and how he was doing it, including stashing drugs outside the camp gate, in the ditch. In regards to economic hardship, the management argued that the griever had not established any hardship, and in fact there was, in spite of him moving his family outside of Alberta at the time and using the project as a catalyst to do that, there was nothing in the offer of employment on the part of the employer that would have suggested that he had to do that. And in fact, at that time, a lot of people were were leaving Alberta due to the price of oil and the lack of political support at both federal and provincial levels of government. So he just had a project that actually helped to facilitate that. In any event, economic hardship was not a concern according to the management's argument to the arbitrator. And the griever has demonstrated no remorse throughout the whole process, and found that there was no extenuating circumstances, and also discussed the prospect of reinstatement was actually fettered by the extent of the dishonesty exhibited by the individual in concealing and going to some lengths to get his marijuana onto the project, or at least accessible to him while he was on the project. In the union's argument to the arbitrator, once on the just cause, the union decided to try to relitigate the fact that the individual followed the instructions of the physicians, and somehow that would, in doing so, he somehow satisfied his obligations to work safely on the project, and that had already been addressed at the first arbitration hearing. Also, the union introduced a fairly curious argument, and I've seen this before, where, especially on hiring hall systems, where unions dispatch workers to different employers and projects back and forth, where a union will try to establish the length of service or characterize the length of service as being the time from which the first time an individual was dispatched to an employer and then to the time of the termination. And in this case it would be 3 years, but I've seen it where there would be a 20-year period where someone has conceivably worked for an employer, but during that 20-year period it might have only been 60 days. But in the past, arbitrators have not accepted, and this arbitrator clearly did not accept that by simply being part of a dispatch pool, sometimes sent out to that same employer from time to time, did not in fact have the impact of extending the length of service for the purpose of calculating severance or determining just cause for termination factors beyond the 4 weeks that this individual worked for this particular employer in this instance. But in any event, the union did raise that issue, and the arbitrator handled it appropriately. Here's the union brought forward, and this bothers me too, but the union put forward the fact that the site management had returned the individual back to the workplace and allowed him to work for 5 days after the individual was finally confronted and admitted to having a prescription for medical marijuana and using that prescription for marijuana while on the project. So the fact that they didn't stand that griever down and just permitted him to work in a safety-sensitive work site, I really hope that someone sat that site manager down for a little learning moment after, because as an employer-side labor relations person, I'll just tell you that that's absolutely cringeworthy. And in fact, something like that, it's a little bit of a miracle that didn't cause enough of a distraction to cause more damage to this case than it did. But in any event, that's just not professional conduct on the part of the employer. But the union went further. In addition to that, just simply argue that that was problematic in terms of the employer being very convincing when arguing that this is done for safety reasons, that they return the individual to work site. And the union also used that as proof that reinstatement was not out of the question, because the employer was ready to work with the individual and demonstrated that he was prepared to work with that individual by carrying on having him on the crew and at the workplace for 5 days following knowing that he was taking this medical marijuana after he initially concealed doing so. And in addition, and this was probably the most interesting component, the union put forward, again, set out the employer's obligations to accommodate individuals pursuant to the Human Rights Act. And this is the part that will actually be the most interesting in reviewing, and this is actually, one of the specific issues that the court referred back to the original arbitrator, was explained to us how you got to the place that you got to, where the employer did not have to accommodate an individual using medical marijuana on a safety-sensitive work site, working in a safety-sensitive position. And we're going to set out the arbitrator's reasonings and get into his concluding remarks on how he ultimately decided in favor of the employer in this case, in part 2 of this series. So stay tuned, and I appreciate your time and attention. Thank you.